party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do wish to reserve time, let me know when you take the podium, and I will do my best to keep track of the clock and keep you apprised of when you're getting close to your rebuttal time. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and stand behind the podium. We've read your briefs and are ready to proceed when you are.
Good morning, Your Honors. My name is Sean Romer, and I represent the appellant, Patricia Pilato. I'd like to reserve 4 minutes for rebuttal, please.
All right.
May it please the Court. We're here because the trial court granted summary judgment in its entirety, dismissing a number of disability discrimination claims that my client had filed against the Nordonia Hills City School District and their business development director, Matt Godler. The trial court erred, I believe, for 3 reasons. First, the trial court erroneously held that Ms. Pilato was not disabled under Ohio law. Secondly, the trial court erroneously held that she did not suffer an adverse employment action. And third, the trial court erroneously held that there wasn't a fact question as to whether the proffered reason for Ms. Pilato's termination or her forced resignation was pretext. Firstly, Your Honor, I think that the trial court relied heavily on pre-AD, and this is a lot of A's, AAA law, the Americans with Disabilities Act Amendments Act, that was passed in 2008 by Congress, which made the definition of disability a lot more lenient. A lot of the cases that both the appellees relied upon and the trial court relied upon were either pre-2008 or the decisions might have been 08 or 09, but the cases were filed prior to that, so they were applying pre-ADAAA law. Congress passed this law essentially to make, well, for a variety of reasons really, but one of the reasons is to get the focus off whether the person was disabled and to focus on whether discrimination occurred. So for instance, my client, I know that you've read the briefs, but my client underwent a complete knee replacement surgery, which substantially limited a number of her major life functions, including walking and, most importantly, working here. She was required to be off of work for 3 months. We think that that alone substantially affected her ability to work for 3 months. Under the post-ADAAA case law, a temporary restriction such as that can qualify as a disability. We think that the trial court erred when it held the opposite. Especially, I believe the trial court disregarded the Northern District of Ohio's decision in Welch in 2012, which specifically said that when in passing the ADAAA, Congress intended to eliminate the restriction. Well, I'll just read it. They said it better than I could. So, Ohio courts would no longer apply the temporary permanent distinction Congress rejected, and that the temporal duration of the plaintiff's condition would not disqualify that condition as a disability under the meaning of ORC 4112.01813, and that's the Ohio Revised Code provision defining disability.
Counsel, I want to ask you a question about the disability issue. Because in reading the briefs, I wasn't sure which way you were arguing, and right now you seem to be saying that it was the surgery itself that caused her to be disabled. I mean, her downtime, her inability to work during that time. I know there's a lot of information in both briefs about pain or issues she had because of her knee prior to that she kept working through. Are you limiting the disability to the surgery?
I don't want to say limiting, but that's the major impact.
And that was a bad word on my part.
Yes, of course, no, of course. That is the major thing that we're focusing on, because she underwent this surgery. She couldn't work for 3 months. Now, I understand that a majority of this time was while the school year they were on summer recess. But one of the reasons that I believe we need to focus on that is that it shows the severity of the disabling condition that she couldn't work and she could barely walk for 3 months. Now, you might say, why does the school district care if she can't work over the summer? I mean, they're going to get her back at the beginning of the school year. I believe that because this shows the severity of the condition, it could give the school district concerns whether she could return to the same type of performance that she had before. Now granted, there is a doctor's note that clears her for work when the school year starts. Being cleared to actually work and performing in the same way that she did previously are two different things. That's one of the reasons why we think that the school district may have done what they did. Secondly, and I'm kind of jumping around here, I apologize, but we also believe that there was Sue Katonic, who was for her direct supervisor. We believe, well, my client knows that Sue Katonic instructed my client to work while she was on disability leave. That's a clear violation, we believe, of her request for the reasonable accommodation of the time off. Secondly, and this gets in actually to my third point, again, I apologize, I'm jumping around a little bit. But secondly, my client was forced to defend herself in this whole situation days after she just underwent major reconstructive surgery. The Matt Gogler gave her an ultimatum as to making these decisions and to responding into what happened right after my client's major reconstructive surgery. She was on Percocet at the time, and yet the school district still gave her these ultimatums that she had to respond. I think that in and of itself qualifies as a failure to provide the reasonable accommodation of disability leave, but regardless, I don't think that there would have been any harm in waiting at least a few months, at least a month, until my client was of more lucid mind to adequately defend herself again, because she had just gotten out of surgery. Secondly, Your Honor, I do believe that Ms. Pilato requested a reasonable accommodation. I think that the trial court held, because of some of the deposition testimony, that Ms. Pilato did not request any kind of help for working prior to her surgery, but I believe I clarified in the deposition, and I cited in my brief, that the reasonable accommodation that she requested wasn't, and this goes, I believe, to Your Honor's question, it wasn't requested for working prior to the surgery, it was the time off for the surgery itself. That's the reasonable accommodation that was requested. And we don't believe she got it for the reasons that I just indicated. Also, the trial court held that my client didn't suffer an adverse employment action. I don't believe the law supports that. Firstly, when this situation occurred, she was presented with three options: resignation, termination, or to be transferred to a different position in the school district. And that's where things get a little tricky, because according to union rules, if my client was going to be transferred to this different position, it would have been very difficult for her to get it because of bidding procedures. We're not sure that she would have actually gotten the job that she would have been forced to try to get if she agreed to continue working. Also, the job that they were offering her was only a 2 to 3 day a week job. So that in and of itself, a dramatic reduction of hours and therefore salary alone, according to the case law, constitutes an adverse employment action. And then third, we think that really this was just a way to get her to resign. There was an email that I found in discovery which Mr. Gogler pretty clearly indicates, and I'm almost quoting here, yes, we would have terminated her if she didn't resign. If that's not evidence that what they were doing was an attempt to try to get her out and make her suffer an adverse employment action, I don't know how I could find any stronger evidence than that. Lastly, Your Honors, I do believe that there is a genuine issue of material fact as to whether the proffered reason was pretext. This goes back to whether Ms. Pilato, while she was on disability leave, because she was being told to work while on disability leave, canceled a food order. Ms. Pilato was a cafeteria manager. Suppose somebody canceled a food order in the food ordering system. Ms. Pilato doesn't think that she did it. She argued she didn't believe that she did it. If she did, she sincerely apologized, and she certainly didn't mean to do it. And the issue that we have with this is that Ms. Pilato had been there for 22 years. She had excellent performance evaluations, had never been disciplined. She was dedicated to Nordonia Hills. She worked in the lunch room serving kids for 22 years. It doesn't make sense that she would purposely try to cancel any kind of food order to deprive them of food for the day. And then also, if we look at the resulting harm of what happened, The only thing that happened was that Supatonic, her supervisor, had to run to the store and pick up a few items. Supatonic testified at deposition, she already does that 10 times a year. And any mistakes that result in her having to do that with other employees who are not disabled, no one ever got fired except for my client, who happened to be on disability leave when this happened. Secondly, Matt Gallagher testified during his deposition that there was no economic harm, or no real economic harm in Supatonic having to take a little bit of time to go get some of the supplies that were missed because of this order. And then thirdly, Your Honors, everyone ate. Supatonic testified that no child was deprived a lunch. All of everything served that day met any kind of applicable standards. So for those reasons, it just doesn't make sense to terminate my client. Again, 22 years, no discipline, very dedicated for these reasons, and happened to happen right after she applied for disability leave. We certainly think there's enough there that a jury should hear this case. Your Honors, that's all I have if there are no further questions. Thank you.
May it please the court. My name is Chris Williams. I'm here with my co-counsel Taryn Weiss. Counsel, the issues before you, frankly, we feel are muddled due to plaintiff's presentation of these issues on appeal. While plaintiff's complaint raised 4 claims, a claim of disparate impact disability discrimination, a claim of disability discrimination due to an alleged failure to provide a reasonable accommodation, retaliation for the reasonable accommodation, and a claim of aiding and abetting discrimination against defendant Gawker. Plaintiff has not appealed that claim of disparate impact disability discrimination. Nonetheless, as the court noted, much of the brief is discussing discrimination and disparate impact disability discrimination. It is the appellee's position that this court should affirm the decision of the trial court granting them summary judgment on all claims, including the 3 claims which were appealed by the appellant in this matter, as there is no material dispute of fact and the appellees were entitled to judgment as a matter of law on such claims. As an initial matter, I wish to address the appellant's claim regarding the impact of the amendments to the Americans with Disabilities Act and how that impacts your analysis of revised code 4112.02, which is the statute under which plaintiff brought her claims of discrimination against the Board of Education and Gawker. The law is clear that while the ADA and the ADAAA and the Code of Federal Regulations that provide guidance on those 2 federal statutes are in turn to provide guidance to Ohio courts, they're not binding upon the court. And certainly the courts have utilized such guidance in order to guide them, but it's not a binding guidance for this court. And plaintiff chose to bring her claims as state law claims rather than federal law claims. So the claims before you today are pursuant to 4112.02, not the Americans with Disabilities Act. Regarding the claims that are before you, plaintiff was the manager for Nordonia's high school cafeteria and was a member of the non-teaching union. In that role, she was on her feet, walking or standing 8 hours a day for years. During that time, there was no indication to the appellees at all that she suffered from any knee pain. There's no testimony, there's no evidence in the record, other than her own self-serving testimony, that she suffered any knee pain. There's no witness statements, affidavits, deposition testimony, documents, anything, medical records, anything other than that.
Well, counsel, that's why I asked opposing counsel the question. If you put that aside, are you asking us to infer she didn't need that reconstructive knee surgery, or can we assume that there's some doctor out there who felt she needed it and she had surgery?
Certainly we concede that she had the surgery, and she did at some point on May 12, in fact, note her supervisor, Supatonic, and indicate that she needed 2 weeks time off from school, from work, so that she could have such surgery.
During that period of time, skip the pre, but let's go to the surgery. Is it your position that she's not disabled under the law?
That is correct. And it's our position for a number of reasons, borne both by the facts before this court as well as the law. Regarding that issue, when the plaintiff went to her supervisor and asked for that time off was freely granted. She was granted the 2 weeks of sick leave, paid sick leave, so that she could have her time off. The only thing she was asked to do, and this was prior to her going on leave, was to create the menus for the fall, because it was anticipated by the district that she in fact would be returning to the position, and they wanted to make sure things were in order for the fall when she returned to work. She was also instructed during that meeting she was not going to work during the time when she was on leave. This is a fact which is confirmed by the union president, whose deposition was also taken as part of this litigation. There is no evidence, however, to support the plaintiff's claim that she was instructed to work during the time that she was on leave. She has made that claim. There is no document to that effect. There's no text, email, witness statement, other deposition testimony, anything other than her own statement to that effect. And of course, it was the expectation of the district that she not work. That is, after all, they're a public school district. Their employees take sick leave on a regular basis, and they're not expected to work while on sick leave, just as she was not expected to work while on sick leave. Instead, in fact, Ms. Platonic, her supervisor, and another cafeteria employee, Cheryl Rosen, was going to perform her duties while she was on leave. So, on May 17th, the plaintiff had her surgery and was home by May 18th. On that same day, Ms. Platonic had placed the food order, which Mr. Romer referenced during his presentation to you. And that food order was for the high school for May 23 to be delivered on that date and provide food for lunch on that day. The way the district operates is sort of a food in and get served on a pretty regular basis. They don't have the facilities to have a large backlog of food. When the food did not arrive, there was an investigation as to why it did not arrive. And it was determined through both the district's investigation as well as working with their food service vendor, GFS, that the plaintiff on May 18 had accessed her account with GFS, logged in, and canceled that food order. The facts in this are not in dispute. The plaintiff herself testified during her deposition that she logged in on May 18 at 7 o'clock p.m. from her home computer to look at the food order. GFS's records show that at 7:15 that same evening, from an IP address which is not a district computer IP address, but someone logging in using the plaintiff's credentials, canceled that food order. Based on that, Ms. Pilato, the plaintiff, was confronted and asked, "Did you do this?" She denied that she had canceled the food order. That resulted in additional investigation by the district, and they learned that, in fact, she had not only been accessing that computer system, but actually had also been accessing the district's employee attendance software system remotely to check on employee attendance while she was on leave. It was at that point that the district immediately terminated her access to any further computer programs or portals so that she could not do anything else that she should not be doing while she was on leave. She was then invited to come to a disciplinary meeting, provide her union representation. She did not say, "No, I don't want to attend that meeting." In fact, she asked if she could attend by telephone. And the EEOC has been clear in their guidance, and we cite this in our brief on page 21, that employer-provided leave in the Americans with Disability Act is the name of the guidance document, that employers may contact employees who are on leave and request information about their progress and otherwise speak to them. And that is what had happened here. Similarly, if she had indicated that I am not able to speak to you at this time, I am on too many medications, whatever the situation, that certainly could have been delayed, but that was not her request.
So you clearly weren't calling her about her progress, are you saying that fell under the, or otherwise speak to them?
Yes, yes, Your Honor, thank you. I think it's also important to note that regarding what the plaintiff's physical condition was subsequent to the surgery, again, there is no evidence in the record about that other than her own testimony and a doctor's note which released her to return to work effective the beginning of the school year. There are no other medical records. There are no affidavits from people who witnessed how she was. There's no copy of a prescription for any medication. There's no physical therapist notes. There's simply nothing in the record other than her own self-serving testimony regarding whether and how she was able to walk, what her condition was, whether she was able to participate in telephone conversations, nothing at all. Rather, the employer, however, has provided evidence that clearly she was able to participate in this telephone call and had the representation of her union. It's also important to note that that union representation, she testified with someone she trusted and she consulted with as part of this disciplinary process. As a result, and the union hearing the arguments, recommended to her that she resign. The trial court notes this in their decision that the decision to resign was something made by the appellant. It was not something forced upon her. She had the option to fight the allegations that she'd engaged in discipline, and she chose to do so. Under the union contract, she could file a grievance if she disagreed with what happened. She chose not to do any of those things. Instead, she chose to resign. Regarding
Before you go on to the next issues, I just wanted to clarify some things with the facts. You had said that she had logged in from her home computer and canceled the order. Now, my understanding from the briefs was that this had happened before with the school district, though the orders had been canceled inappropriately, or by mistake, or whatever you want to call it.
From the briefing, I'm not aware from the briefing that that was the case. I know there had been testimony during deposition that occasionally, if an order is not placed in a timely fashion, it'll get held over to the following. If it's not placed in time for there's a Friday sweep where the orders are swept up so they can be then put into the system, and GFS can put together the order to deliver it. And if it's not timely submitted, it can result in the order not being delivered. But that was not the case here. The district, in contacting and speaking with GFS was able to determine that in fact this order had been canceled, and it was canceled by someone using the plaintiff's login credentials, and they were even able to track the IP address from where that cancellation had occurred. And that IP address, while we can't determine precisely which IP address it was, which computer, it was not a district IP address, which is normally where these orders are placed or modified or held or even canceled if need be.
It seems like an awful lot of investigation. Is that something the school district does when there's a mistake made on any of its, food orders or anything? I mean, I've worked with schools for years, and, some have some experience, and believe you me, schools make mistakes, people make mistakes.
Sure.
So why all the involvement with this case?
Well, and that's a fair question. From the district's perspective, when the order didn't show up, the initial concern was, frankly, what did GFS do wrong? And it was GFS that then conducted the investigation to prove to the district, no, we didn't mess anything up here. It wasn't our error, it wasn't our failure in not providing you with the food you ordered. In fact, here's what happened with it. It was only when the district then learned that, wait a second, someone using the plaintiff's credentials logged in and canceled this order when she's on leave. Why is she doing this? That the district then began further investigation and asking the plaintiff about that.
Thank you, Council.
Council, there's some reference in the school's brief regarding other behaviors that may have caused the disciplinary action. What's in the record? Or is it even a material? I mean, there's some reference to some activities regarding bullying or being disrespectful to other cafeteria employees. It just kind of hangs out there. Was it germane in this motion here?
It was not very well developed as part of the factual record. I do have information about that.
Whatever's in the record, I wondered if there was something.
No, there had been, I think, some testimony by Ms. Patonic in particular, that there have been employees that had come to her concerned about how the appellant had treated them during the time that she was a supervisor. Even though she is in the union, as are her coworkers, she held a supervisory position in that cafeteria. So she was a supervisor, and there's a number of other cafeteria workers that she supervises, helps keep track of their hours. And there were concerns by some of those employees regarding, I think this was expressed by Ms. Patonic during her deposition, about whether the plaintiff had taken action to deny her overtime leave, or had acted in a bullying way toward them.
And is that germane to the question of whether or not she was given the leave she requested?
No, I don't.
Again, it's just hanging out there. So, can I ask you one more question?
Please.
The determination of whether or not she was given the leave requested, or whether or not she was asked to continue in her duties remotely during that period of time for those last couple weeks of school, is that question material to whether or not she is disabled, or whether or not an adverse employment action occurred?
I don't believe it's germane to either one of those issues. I think the plaintiff's allegation, if I understand, is that she was not actually given a reasonable accommodation because, in their contention, that she was asked to work. In fact, again, not only is it the testimony of both the employer as well as the union president that employees are not to work while on leave, but after it was discovered that she had been accessing the computer system, her access was cut off when she was confronted and asked, did you do this? And so why did you do it? She initially denied that she had done so, and then when further pressed, sent both emails and texts, which are referenced in the brief or on the record, that, quote, no one ever told me I couldn't do this.
So is it that question then germane to whether or not a reasonable accommodation was made to an individual who expressed that she had disability to employer?
It's our belief that because she was not instructed to work, she was afforded any reasonable accommodation. So it'd be germane to the extent that she was afforded the paid time off. She was not denied the paid time off. There's no allegation she didn't get paid, that her insurance wasn't covered during that time. She didn't continue to accrue seniority and other benefits of employment while on her paid leave. In the brief time I have left, I just wish to note that even to the extent that plaintiff could demonstrate that she was disabled, that she was either denied reasonable accommodation or somehow retaliated against for that reasonable accommodation, such as she's alleged a prima facie case of disability discrimination or retaliation, the burden shifting to the employer is then the burden of production that there's a legitimate non-discriminatory reason, which we have provided, and I think is amply set forth in the briefing we discussed here this morning. At that point, the burden shifts back to the employee to demonstrate there was pretext, and there's simply no evidence of pretext. Even counsel's own statements that we speculate or we believe or have some reason to believe are not evidence of pretext, and that burden remains with the plaintiff.
And with that, your time is up.
Thank you.
Counsel, you have 4 minutes and 33 seconds remaining.
Thank you, Your Honor. I just have a few points I wanted to point out. First, with the reasonable accommodation, one thing to take into consideration is she requested disability leave, and she was terminated before she even got the benefit of that disability leave. To the extent that this court finds that there's no fact issue as to whether she was told to work while on disability leave, she certainly didn't get the benefit of the entire disability leave for having been terminated prior to getting it. We believe that that also is a failure to reasonably accommodate. And again, remember, we also have a retaliation claim in that she requested the leave and she was fired a few weeks after that while on leave. To the extent that the court does want to focus on whether she was told to work while on leave or whether she was doing it on her own accord, I would ask you to consider her motivations. Why would she be working on leave? A, if not told, and B, certainly not for a devious purpose. Let's say there was a misunderstanding, which we believe that she was told, but if you examine her motivation, I think it raises a fact question that a jury needs to consider as to, she wasn't told to work while on leave, why would she be working? And second, sorry.
Let me stop you real quick. I think the argument is she didn't meet her next burden after the burden shifted back to her to produce something in terms of evidence that she was told to work when she was on leave.
And we would, yeah, and that is an issue, I agree, but I believe if examining the motivation is something that a jury could consider. Secondly, I want to make it clear that we did present medical evidence of her request for an accommodation. There is a doctor's note which was from the Crystal Clinic Orthopedic Center indicating that my client was, and this was submitted as part of the summary judgment briefings and certainly mentioned in my appellate brief, that she was undergoing surgery and needed time off until I believe it was August 24th, 2017. I briefed this, it's mentioned in my brief, but as far as the other ways in which her major life activities were limited, a plaintiff is allowed to, it is sufficient for a plaintiff to testify as to those. But again, I've got the medical record in there as well, so I want to make sure that the court is clear on that. And lastly, while it is true that Ms. Pilato had union representation, I don't believe she ever was ambiguous that she thought that was good representation. And frankly, if you're asking why she didn't do anything about it, that's why she got me involved. We are doing something about it. So with that, Your Honor, if there are no further questions.